Hello and welcome to the Kenneth for Chem and Lawless Legal Podcast, the NJ Laws Tube, looking at recent cases by the criminal courts. In this edition, we look at the New Jersey appellate case where the court held there is no automatic right of a DWI defendant to have their attorney inspect the inside of the police station. That's State versus Carrero, Carrero, and State versus Baluska, Baluski docket. And in this case, the defense attorneys had made requests to examine the inside of the police station to see where the Alcotest breath test was conducted. And there was two municipal courts that had reviewed this, and then the law division said yes, they could. So the appellate division in this case reviewed discovery orders separately issued in two DWI cases, which authorized defense counsel and or defense experts to inspect and photograph rooms within police stations where their respective clients had provided breath samples on the Alcotest device in order to verify that the tests were properly administered. In the Carrera case, the court had granted access to ascertain whether devices emitting radio frequency interference, RFI, have been located in the station within 100 feet of the testing area. In Baluska, such access was granted to help ascertain whether the interior layout of the station physically prevented a defendant from being observed for the required 20 minutes before testing. The court reversed the discovery orders because they felt that neither defendant had shown a reasonable justification to conduct the requested inspection. So they didn't specifically say it can never be provided. They just said in these cases the defendants had not showed reasonable justification. There was no certification. It was just legal argument basically by the defense attorneys. The court concluded that Carrero's request was insufficient in light of the Supreme Court's binding legal and evidentiary determination, State versus Chun, the New Jersey Supreme Court case at 194 NJ 54, which held that the Alcotest is designed in a manner that is, quote, well shielded from the impact of any potential RFI, end quote, and also in light of the state's countervailing security interests disfavoring routine civilian access to the interior of a police station. The court also concluded that Baluska's request was likewise insufficient because he has presented no affirmative basis to believe that an officer failed to observe him for the 20-minute pre-testing required by Chun, also in light of the state's countervailing security interests. So conceivably, in future cases, defense can have a certification by the defendant prepared in connection with a proposed Rule 104 hearing where the defendant can put in a certification, someone left the room, I was chewing gum, I burped, I vomited, etc. And we don't believe that those type of certifications would be admissible in the actual trial itself. And that's State versus Carrera, State versus Baluska, docket number A3232-11T3. For other information on criminal and DWI matters, visit website njlaws.com or website benotguilty.com. That's benotguilty.com. For other information, call the Law Office of Kenneth for Chem at 732-572-0500 in Edison, New Jersey. Thank you and good luck.